Hello and welcome to The Big Picture. A meeting of all the parliamentary parties held yesterday in the Parliament has expressed serious concern over what they call as erosion of the supremacy of Parliament. Though this is an issue which has periodically been discussed in this country, the present trigger for this expression of concern by the parliamentarians are some of the recent court judgments. One concerning the eligibility of those who can contest elections, and also another one declaring Section 8(4) of the Representation of People's Act, which gave convicted legislators and parliamentarians a cover to continue as members as long as they had filed an appeal in a higher court, has been held unconstitutional. There have also been many other instances in the recent past when Parliament has felt, or parliamentarians have felt, that their powers are being usurped by the judiciary. In this context, the concerns about erosion of supremacy or sovereignty of the Parliament are real today. Why it has happened and how to ensure that there is no further erosion. We will discuss all this today with an eminent panel of guests. I have with me Shankar Aiyar, a Congress MP who has been a member of both the Lok Sabha and Raj Sabha, apart from having been honoured with the Best Parliamentarian Award. Justice R.S. Sodhi, a distinguished retired judge of the Delhi High Court, Raju, a distinguished senior advocate in the Supreme Court, and Smita Gupta, deputy editor of The Hindu, who has been covering the Parliament for over 2 decades. Welcome to all of you. Justice Sodhi, I would like to come to you first. You think that this concern being expressed by parliamentarians about the erosion of the supremacy of the Parliament, and this time the target seems to be directly the judiciary. They say that judiciary is usurping their powers. You think there is any validity or in their concern?
Yes, there is certain validity in the concern, all right. But be assured that the courts are not concerned about, or nor do they wish to cross any lines drawn within the Constitution, giving Parliament the supremacy within its own sphere.
Yes.
But the only thing that I wish to point out is, when the Parliament itself creates a hiatus or leaves a vacuum which is necessary to be filled by somebody else, it is only then and then which the court may be stepping into. And it may appear at some point of time, of course, at some judgments it has appeared, that there is a slight digression from their own in the field. But by and large, I do not think the judiciary is trying to overstep or trying to take over the functions of Parliament.
Two recent judgments seems to have triggered this, feeling among the parliamentarians. One is about this, that a person cannot contest if he is held in custody, whether he is convicted or even as an under trial. If he is in custody, they are not allowing a person to contest. This is one thing, and the second one, of course, is the Section 8(4) of the Representation of People's Act. You think in these two cases the parliamentarians have a reason to feel the way they are feeling?
See, since they are this affects the parliamentarians, obviously there is going to be a lot of heartburn. And it may be that the interpretation given by the Supreme Court is not really that palatable. But however, it is an interpretation, and so long as it remains on the statute book, it is the law. If it is absolutely unpalatable, surely the Parliament is well within its powers to legislate and alter or amend.
Okay.
To legislate, yes, it can do that.
Okay, let me get Shankar Aiyar in on this. Shankar Aiyar, do you think that these expressions of being made by political parties, that the supremacy of the Parliament is being eroded, do you think it's a reality?
I think we ought to recognize that Parliament is supreme and sovereign in making the laws of the country, in changing them or in amending them.
Yes.
But that the courts are an institution of the Constitution whose job it is to interpret the law. And if they interpret the law in such a way as to not reflect the view of Parliament, Parliament remains free to amend the law, as it did, for example, in the case of the Shabano judgment.
Right.
So I am not sure that this is cause enough for a confrontation between Parliament and the judiciary, and to use expressions like the supremacy of Parliament is being eroded. The supremacy of Parliament cannot be eroded, because whatever the judgment of the Supreme Court, it's always possible for Parliament to rewrite the law in order to ensure that its interpretation is not the same as had been given before the law was written.
Right. But
so in principle, I see no reason at all why this should be regarded as confrontational. But the specific matters that you have raised,
yes,
perhaps on that I would like to express a view now or later in the program.
You can say what you want to say on because these two seems to be a very touchy issue. These two judgments. What is your view on that?
Well, my view on the question of having the person not attend Parliament if he is convicted,
yes,
is based on the fact that it was expected that cases where elections are contested would be settled one way or the other within 6 months.
Yes.
But as far as I can remember, in the last 22 years that I've been in Parliament, there's been one case of Ram Kapse where his membership was terminated,
right,
and that too just a few weeks before his term was to end anyway.
Right.
So it does seem that there's a kind of collaboration between the judiciary and Parliament to ensure that these kinds of disputed cases are not resolved, leave alone within 6 months, not resolved within the lifetime of a given Parliament, and then the whole case becomes infructuous.
Absolutely.
If that Parliament is dissolved and they move to another Parliament.
Absolutely.
So in these circumstances, I think it would be valid to say that if a court has actually given an order of conviction, then instead of waiting for the appeal process, it should be finished as quickly as the membership should be terminated.
Right.
And I think this will give an incentive for the appeal process to be expedited instead of being delayed, so that the member concerned can come back to Parliament.
Exactly. That's 6
one.
months.
The second thing is...
Yes. Yes, please continue.
The second is a completely different issue of being in police or judicial custody.
Yes.
I'm afraid the kind of nexus that there does exist between state governments in particular and the lower judiciary is such that there could be a lot of false cases foisted, and long before conviction, a person finds himself in custody,
yes,
on a case that will eventually be dismissed. But because he's in custody, he's not allowed to contest an election.
Absolutely.
So the first case, I'm tending to agree with the court. On the second, I'm tending to disagree with them.
Okay.
And clearly on this matter, we need to have a clarity of view in the legislature, and the view in the legislature will have to prevail in the making of the law, the changing of the law.
Okay. Mr. Raju Ramachandran. Raju, the concern seems to be that more and more, overactive judiciary taking up, usurping the powers of the Parliament and passing laws, or interpreting laws. They're supposed to interpret law, but virtually they're rewriting laws. This is the concern which is expressed by the political class. Do you think these concerns are real?
Girish, let's get the perspective right. Under our constitution, the judiciary has the power to review laws.
Yes.
And the judiciary has the power to strike down laws of Parliament if they either violate fundamental rights or if they are lacking in legislative competence. That is a power given by the constitution. That's what the court is meant for.
Right.
So if the court strikes down a law, this is not judicial overreach. This is not judicial activism at all, because this expression is bandied around so frequently without understanding what it means. Now there is always, because the court is given this power under the Constitution, there is always a creative tension, and that's how it should be.
That's how it should be.
That's how it should be between the legislature.
That's how the Constitution makers envisaged it.
Absolutely, and the judiciary. And as Mr. Shankar Aiyar rightly says, if Parliament feels that its intention has not been properly understood by the court, Parliament always has the power to remove the basis of the judgment by clarifying its intention and remove the underlying basis of the law as it was understood by the court.
That is exactly what they're trying to do now.
Exactly, and so that
and you think that it's a valid thing what they're doing?
It's a valid thing without the hype about judicial overreach
or
and
the
without
erosion,
competing supremacies.
Or they are talking of erosion.
That's right.
They think that they are overreacting.
Either they are overreacting or the media is portraying it in a manner in which it is not meant. Because as Mr. Shankar Aiyar has put it, I think that's a legitimate view for a parliamentarian to put forth. And he's not talking of supremacy or competing supremacies.
Smita, you think Raju says that it may be that the media is overhyping the concerns of the parliamentarians, or you think that these concerns are really, do you see these concerns really troubling them? These things troubling them?
Well, I think the media is responding to the responses of the political class, which has spoken of erosion of parliament.
Right.
Now, I agree with Mr. Aiyar and Mr. Ramachandran that actually there is no erosion of parliament, but the political class today sees itself under attack from everybody. So therefore, any kind of judicial intervention is interpreted as erosion of their it's actually the entire political class which is under attack, not Parliament as an institution. And the second thing that I'd like to say is that given that the political class is under attack, it is for the political class itself to initiate reforms rather than other institutions stepping in. For instance, you take this whole question of the CIC.
Right.
Saying that even
the
RTI should be brought under the RTI. I mean, the government has given its reasons why politicians should not be brought under the Act, because political parties don't constitute an authority.
Right.
Whatever it is, I feel the reforms must come from within the political class. Just as we in the press often say that, when people talk about regulating the press, we always say that self-regulation is the best.
So, yeah, Justice Sodhi, do you think that, you spoke about a vacuum being created and because of which sometimes the judiciary has to step in. You think sometimes the judiciary overreaches? Raju Ramachandran thinks that in most of these cases, they are not overreaching, they are just doing their job.
See, that's true. It's not the question of overreaching, really. Like I said, look, if for example, the Parliament itself is not functioning, and there is an urgent need for the nation to move in a particular way, or it has to move, then someone has to step in to take its place.
So what
but it's not really overreaching all the time.
So what you are trying to say is there is actually an erosion of faith in the Parliament or parliamentarians rather than the erosion of the supremacy of Parliament.
No, I think it's the Parliament itself that can only erode its own supremacy. Nobody else can.
Okay, Mr. Aiyar, you think that the politicians, the political class, nowadays have been stuck with a siege mentality. Like Smita was saying, that whenever there is a judgment, they overreact, they think that they are being attacked because generally there is some kind of a, the erosion of faith about the politicians in this country. So do the political class suffer from a siege mentality? Mr. Aiyar, that's for you. Mr. Aiyar, can you hear me?
I'm sorry. I didn't realize it was for me.
Yeah.
I can hear you very clearly. I didn't realize that the question was directed at me.
It couldn't have been for anybody else here.
Let's be a little bit more specific here.
Yeah.
In the case of the Right to Information Act,
Yes.
it was a right to information about the functioning of government. And obviously political parties are not the government. So when you attempt to extend the ambit of the Act to cover a class of citizens that was not originally within its ambit, that entity is bound to react. There is, for instance, absolutely no RTI on the media.
Right.
There's no RTI on the corporates. And if we attempted to have an RTI on the corporates or on the media, then I'm sure the media and the corporates would cause hell. I mean, they'd object very, very strongly.
Now
and so
there is a lot of
I do
talk now of
think it
getting
is
BCC.
important.
Mr.
It's
Aiyar,
not a, it's
Mr.
one,
Aiyar, sorry. Mr. Aiyar,
yeah, one is,
BCCI.
so one is not,
People want
this is
to
not a
get
question of,
BCCI and
it's not,
RTI.
I think what you ought to recognize that the RTI was conceived as securing information on government and governmental authorities.
Right.
And therefore, there is no play with words involved in saying that political parties are not authorities.
Right.
The fact is they are not government authorities.
Right.
Even as the BCCI is not a government authority.
Right.
Now, whether the BCCI should be clean and be seen to be clean and be held responsible for being clean is a separate issue to whether it should be covered by the RTI.
No,
why is it necessary to be covered by the RTI to be vulnerable to the CRPC?
No, but Mr. Aiyar, my question was that does the political class in the present atmosphere of cynicism against the entire political class, does it suffer from a siege mentality because of which these kind of judgments are seen as something, an attack on the parliament, an attack on the system, an attack on their supremacy?
Well, I as a politician don't feel under siege at all. And it is likely, it's entirely possible to interpret their talking of an erosion of parliamentary supremacy as an example of being paranoid about this. But the fact of the matter is that the substantive point being made by the political class in these specific cases is a valid one. And I think the substance has to be addressed rather than the psychology of the persons who are making the points that they're making.
Okay, Raju, you think that there is a problem with the political class?
Girish, there's a point which I wish to make.
Yes.
The political class has been supine on an issue where it ought to have asserted itself right from 1973, when the Supreme Court propounded the basic structure doctrine. The political class has been silent.
Yes.
Earlier in 1967, when the first inroad was made into Parliament's constituent power in the Golaknath case,
right,
there was the Praja Socialist Party MP Nath Pai,
right,
who made it his mission to reassert Parliament's sovereignty. We don't have a Nath Pai today.
Yes.
So in 73, basic structure doctrine, political class meekly accepted it.
In
the Keshavananda Bharti case. 20 years later, this is 40 years, 2013 is 40 years of Keshavananda Bharti and 20 years since the Collegium case.
Right.
Now that is...
Now Collegium is an issue. Now
again,
Collegium is being used as a... We'll come to the Collegium.
No, but the court has first in Keshavananda Bharti usurped really the power of Parliament,
right,
by saying we will decide what is the basic structure of the Constitution.
Right.
20 years later, the court creates a new institution, the Collegium,
right,
unknown to the Constitution.
Right.
And the political class has accepted this.
Right.
It is only now, 20 years later, that they are coming together to say, let's have a National Judicial Commission.
Right. But this national, when in this kind of an atmosphere, the talk of National Judicial Commission will only exacerbate this impression that the conflict is only heightening between the judiciary and Parliament.
No, but this is where Parliament really needs to assert its sovereignty as a constituent body.
Right.
if you can't resist these larger interventions which are illegitimate, this is activism.
Right.
If you can't resist that, then you can't resist these smaller interventions. For instance, the recent order of the Lucknow bench of the Allahabad High Court saying caste-based rallies.
Caste-based rallies cannot be held.
These
Banning
are the
caste-based
areas where the court is treading on forbidden ground.
Absolutely.
And therefore the political class needs to address the central issue.
You're essentially saying that political class has to blame itself for whatever situation
Absolutely,
they find
because they have acquiesced in the larger activism.
Mr. Aiyar, what? Mr. Aiyar?
Yeah.
So, you know, this is a very, what Raju says is...
Yes, I'm listening.
What Raju says is a very valid point. Last 40 years, the political class has acquiesced itself, and now suddenly they wake up and then, you know, start shouting that, you know, our supremacy is being eroded. So the blame lies squarely on the political class for whatever situation they find themselves in. Do you agree?
I don't think this is the juncture at which we are going to be apportioning blame. There were two key judgments that were cited just now.
Yes.
The Golaknath case and the Keshavanand Bharati case.
Right.
And these are called the larger acts of judicial activism. But that larger act of judicial activism was regarded by Parliament as a legitimate way of interpreting the Constitution. So I don't see this as acquiescence. I see this as agreement. And when minor acts of transgression take place, if the politicians feel that this is an interpretation that is not legitimate, then to protest that interpretation or to correct that interpretation is, after all, a fundamental function of Parliament.
Justice Sodhi, is that the way you look at it? Did you agree with Raju that that all these years the political class has taken it lying down when the judiciary has overreached?
No, I don't think that is really correct. You see, it is all right to say that the courts decided what was the basic structure of the Constitution, but like Mr. Aiyar says, that this is what the Parliament agreed to. Parliament could very well have said, no, we don't agree to you. We don't agree with this view. But they did. They said, already, here's a very sensible suggestion coming out, and all right, we think it's good. Well, merely not opposing the court's decision does not mean that they are giving up their rights. It's just maturity, I think.
It's maturity. Raju?
Well, that's a viewpoint, but
you still
hold the long-held view of mine.
You still hold the view that this is...
Absolutely, and I've held this view and articulated it in different fora, in writing and speaking, that this has been a case of complete surrender to judicial supremacy.
Smita, you know what Raju says is very interesting, but you know it's very interesting that Shankar Aiyar thinks that it is not acquiescence, it is agreement. You think that this kind of issues have come up now because of this kind of a surrender, as Raju says, in all these years of the political class judiciary?
The fact is, Parliament did accept it, did acquiesce with it. But today, I think the political class is under attack. I mean, the quality of what happens in Parliament has deteriorated. The whole system has deteriorated. We have currently a weak government.
Yes.
So I think we are seeing far more discussion on these issues right now.
Okay. Raju, I want one more thing. When you talk, when this talk of erosion of supremacy is, takes place, what is it that they are actually talking about? Erosion of the supremacy means erosion of the lawmaking authority of the Parliament. Is that what is being discussed?
That's how I understand.
Yes.
The objection.
Yes.
But as I have tried to explain, and I think Mr. Shankar Aiyar is also in agreement with that view.
Yes.
That this is not really erosion, because you can always step in and clarify your intention if the court hasn't understood your intention correctly.
Right. So, Justice Sodhi, Is this what the issue is now all about? About the lawmaking authority, and and for major political parties to come together in a meeting and say that we have to step in now. We cannot just allow this to happen. Our supremacy, the parliament supremacy, is being eroded. Are they talking about their own lawmaking powers?
Their lawmaking powers were never in doubt.
Never in doubt.
Look, the Parliament is the only forum that makes law. It was never in doubt.
But Justice
the only thing is filling in blanks where there were blanks.
Justice Sodhi, when these recent judgments especially, and some of them in the past also, there is this feeling, there are these commentaries written and views expressed that court has taken over the lawmaking role. Court is deciding what the law should be. And court is interpreting what not just interpreting but also suggesting what the law should be. You think that kind of a approach is not the right thing, and you think that's not happening actually?
It may be happening. Though I don't want to run away from that. But and also, yes, the court has been suggesting certain amendments where they think it's necessary.
Right.
But all said and done, it is actually the Parliament that will ever do it or not do it. The court themselves cannot run the country.
Absolutely. Mr. Manishankar Aiyar, last words to you very quickly. How should the Parliament, how should the parliamentarians, how should the political class ensure that this concern of theirs, that their authority or sovereignty is being eroded, how do you ensure that it doesn't get eroded further?
We should do it sensibly. We ought to recognize that the political class is the only class in India that is responsible to public opinion.
Yes.
And can be easily brought into office through public opinion as it can be removed through public opinion. So the political class should ensure that its actions do not result in its being denigrated, in its being looked upon as being an undesirable decision. So bearing this in mind, that we have to be sensitive to public opinion, instead of crying foul if the judiciary gives a particular interpretation, we should just self-confidently say that this is not the correct interpretation of the law, and this is how the law reads or should read. And then we move on from there.
Okay, I think on that note we need to end. I think you have struck the nail on the head talking about public opinion and how public opinion matters for political parties and politicians. They should ensure that in the latest round of what is happening also, they should ensure that they don't go against the public opinion on these issues. Thanks to all my guests, Smita Gupta, Justice Sodhi, Manishankar Aiyar and Raju Ramachandran. Please keep watching. We'll come back with another issue, Big Picture, same time on Monday. Meanwhile, have a great weekend.